Hi there, Misha Gill with Speedwell Law. In this video, I'm going to talk about transferring your checking account over to your living trust and how to do that and why you might do that. So you would put your checking account, your bank account, in the name of your living trust during your lifetime so that you guarantee that that asset is going to avoid probate. There is another way to accomplish the same thing, similar thing, by establishing a pay-on-death designation on the bank account, and that does avoid probate. However, it does not allow for management of that asset by the trustee during any period of your incapacity. And so transferring the bank account over to your trust is useful and beneficial and stronger as a solution than leaving the checking account in your name individually with a power of attorney on it with a pay-on-death designation. The most complete solution is to transfer it over to a trust. Okay, now how do you do that though? The problem is that banks don't let you. Banks do not let you just simply retitle a checking account into the name of your living trust. Okay, and so what do we do? How do we accomplish this objective of getting the bank account into the name of your living trust? So what you have to do is you have to open a new bank account in the name of your living trust. And you would do that with your certification of trust and your social security number. The living trust uses your social security number as the tax ID of the trust during your lifetime. And you prove that the trust exists with the certification of trust. If the bank says, no, we don't like the certification of trust that you're providing to us, we want it on our form, that's okay. You can use the certification of trust provided by your attorney as a model to open that checking account. So once you open the checking account in the name of the living trust, what then, right? You still have money over in that individually held account. And so the issue there is that if you were to close that account right away, all your auto debits and auto credits would be disrupted. So you don't want to do that. You don't want to close it right away. Instead, it takes time. What you have to do is you have to transfer over time your funds from that original checking account over into the living trust checking account. And so at first, you can probably transfer a bulk of the funds in that individually held checking account over to the living trust. What you need to do is remember to leave an amount that in that original checking account that is sufficient to meet your auto debits and auto credits, so that you don't incur any return check fees or overdraft fees or whatever. And so you move the majority or the prudent amount that you can over to the checking account. In Virginia, you want that amount to definitely be less than $50,000 because that's the amount that gets you into probate automatically. Less than $50,000, you can use a small estate affidavit. Okay, so you transferred a majority of the funds over to the living trust checking account, and you still have the old checking account. Now you got to start moving those auto debits over to the checking account. So your utilities, your automated credit card payments, your Netflix subscription, whatever it is that you have coming out of your original checking account, you want to move it over to the living trust checking account. Then, after a while, once you're sure that you've killed all the auto debits from that original checking account, then you can transfer the remaining amount over to the trust account and kill that original checking account. Congratulations, now you have moved your checking account from your individually held name over to your trust name. Now, it's a little more involved of a process, but as I described at the beginning of the video, it's worth it for incapacity reasons and for probate avoidance reasons. Okay, a couple other notes about checking accounts. One other thing that might be difficult for you is if you're married, you probably have a joint checking account with your spouse. What do you do then? Especially if your attorney put together two trusts, one for each member of the couple. Well, a couple of things. You could either leave that joint checking account open as is because it will pass by operation of law to the survivor of you, and so then it does not require a probate in order to transfer to the person that you love and trust and want to inherit that asset. So you have an option of just leaving the joint checking account as is and addressing it when your spouse passes away. Now, that is not the best solution for incapacity, and obviously if there's a common accident between the two of you where you both perish at the same time, that's a problem. It would be picked up by the pour over will to get to the appropriate trust, most likely, but that's obviously something that you would want to avoid. If your bank allows you to establish a pay on death designation for a joint bank account, yes, you should do that. Do it 50-50 to each living trust. Okay, another thing, pay on death designation for that original checking account while you have the living trust account open and you're moving stuff over to it. You should establish that pay on death designation to cover you during that interim period where you are moving the funds over from the original individually held checking account over to the living trust checking account. The pay on death designation is going to cover your butt there, and it is wise to do it. And you should put pay on death designations on every checking account that you have and that's individually held to the trust if you're going to let that ride in any ways. Ideally, your checking accounts are titled in the name of your living trust. All right, thanks. Bye.